Okay, we're going to talk about getting practitioners into the classroom. Why me? First, I'm a full-time practitioner. I'm also an adjunct on 4 different faculties. I'm an ETL fellow. I recently published a textbook on experiential learning. So I have a few experiences with as the practitioner in the classroom. As you know, legal curriculum's under fire. The headlines more or less say it all. What they don't teach law students, lawyering. What's a first-year lawyer worth? Not much. 97% of recent grads think that the third year should be practical skills training. We have an issue that we need to deal with. We also have a few important commentators weighing in. Our Chief Justice of the Supreme Court, what the Academy is doing, as far as I can tell, largely of no use or interest to people who actually practice law. The ABA working paper, which we talked about earlier today, similar about the curriculum not covering practical skills used for jobs. Now, preaching what they don't practice, faculties generally do have no or very little practical experience. Average 3 years practical experience. Tier 1 schools, less than a year. Tier 4 schools, about 6 years. Surprisingly, about half the lawyers in Tier 1, the faculty in Tier 1 schools have no experience. That creates a dilemma. Law students need more practical skills training. Most faculty lack the practical experience to teach the practical skills. So, what are we going to do about this? We are going to look at the rationale behind practical skills training, the deviant tradition. This was 20 years ago. Professor Schoen spoke to the AALS and laid out how we learn what we do. You learn it by doing. You learn it in the presence of a senior practitioner. You learn it with other people doing it, and you do it under supervision. The current methods of teaching, case study presents a narrow view of law. Few matters are actually litigated. What is litigated is not necessarily what matters, and good lawyers create documents and legal frameworks that avoid litigation. That's what the practitioner does every day. The opportunity is to use untapped resources. Now, Wes Porter, who you've recently heard from, has described them as the advocacy professors, clinicians, legal writing instructors. What I'm concerned with is that they are categorized as second-class citizens. Then, of course, you come to the adjunct professors. We have no class. The opportunity. Who better to teach lawyers to do what we do than those who actually practice law? I'm talking about reinventing and augmenting doctrinal teaching, not replacing it. How do you, and there are examples up here of teaching contracts with actual contracts and other things that incorporate practical skills. Add practical insight, bring law school and the profession closer together, enliven and inspire students, and demonstrate how law is used to achieve client objectives. And don't forget, add transactional practice, because over half the lawyers that graduate will not do litigation. Reform brings more rigor to the legal education. Students find it difficult to synthesize cases. Applying knowledge to problems should be an essential part of legal education. Active learning engages the students and leads to deeper thinking. The current book, What Best Law Teachers Do. This is what we're talking about. Carl Okamoto, faculty member at Drexel, did a recent survey of faculty. He asked 2 basic questions. Is there value of having students interact with practitioners? Overwhelming yes. How are we going to do this? Very divergent reviews. The summary of it, it's a great idea, but maybe not in my classroom. The threat. Practitioners pose a potential threat to tenured faculty. It requires classes to be restructured. The practitioner may highlight what faculty does not know. The practitioner may get higher ratings than the faculty member, and it creates more work. There's work to do this. The challenge, get the right practitioners. They need time to teach, and they actually have to be able to teach. We need to integrate them with faculty, and what they need is a roadmap to the classroom. Develop materials, provide training, pair them with experienced instructors, minimize their time, and maximize their impact. Now, focus on what students really need to know. Teach doctrine, but add an applied context. Address issues in transactional practice, not just in disputes. Introduce the building blocks of business documents to focus on the issues, and that's relevant to both transactional practice and litigation. You need to understand a contract to litigate it. Imagine the power of combining critical thinking on legal issues, using full-time faculty, and the critical thinking on applying law to address practical problems and achieve client objectives. That's my dream. I think everybody in this room shares that dream. There are naysayers. I don't want to dwell on them. There's some recent articles. I don't think that their position of maintaining the status quo will be the future. I think we are going to see change as we've been discussing about all weekend. Solution: teach practical skills, involve the practitioner to augment the doctrinal instruction, integrate faculty and practitioners, involve those who practice to teach skills necessary for practicing lawyers, and to develop the means to facilitate practitioners getting involved in the classroom. It has a positive impact. These are quotes from student reviews. They're of my class, I confess. This is by far the best law class I have ever taken. One of the most valuable experiences a student could get in law school. No shameless self-promotion here. But it does resonate with students. One of my students summed it up. You can read about driving your entire life, but you wouldn't really know how to drive unless you get in a car and turn it on. The purpose here is to give the student keys to the vehicle, drive. That's the role of the practitioner in integrating the practitioner into the classroom.